In a criminal case, can a judge deny an application for an independent source hearing after suppression and just rely upon the minutes of a prior hearing? To find out, you have to read People v. Williams, but it's 9 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People v. Williams. The citation for this case is 2024 New York Slip Opinion 02128, published by the Court of Appeals on April 23rd of 2024. The issue in this case is whether after a failed probable cause hearing, the judge is allowed to use the testimony from the probable cause hearing in place of having a separate independent source hearing. I'll explain all that in a few moments. What you have to understand to appreciate the context of this case is first that in a criminal case, a defendant will frequently have what's called a probable cause hearing to determine whether the arrest that occurred of the defendant took place after probable cause was developed. You can't arrest someone and then get probable cause. You have to have probable cause before you arrest the individual. If there's a failure of that order, if the arrest is not preceded by probable cause, then it's subject to what's called the exclusionary rule, which says that when police are found to have acted illegally or unconstitutionally, the evidence which they obtained by the exploitation of that illegality is suppressed. They can't use it at trial. So it's supposed to dissuade violations of the Constitution, because if you try to violate the Constitution to get evidence, that evidence is going to be suppressed anyway. There is an exception to the exclusionary rule, which is the independent source doctrine. So there's actually several exceptions, but one of them is the independent source doctrine. And that says that a court does not need to suppress evidence if the people can show that it was acquired by means that are sufficiently attenuated by the fact that there's an independent source to the acquisition of that evidence. So if my next door neighbor commits a crime and the police do a bad photo ID or a bad photo array or a bad lineup, which is unconstitutional, if it's found to be unconstitutional, it doesn't mean I can't independently come to court and say, that's the guy, because it's my neighbor. I know my neighbor. I have a source independent of the bad ID that would allow me to conduct an in-court identification. That's an independent source. And you actually have to have a ruling about whether there is an independent source before you can conduct an in-court ID. So an independent source hearing allows, in fact, is required before you can bring in evidence that would be otherwise suppressed. Okay. It cannot come in without first determining that the evidence is not tainted by the illegal identification or unconstitutional action by the law enforcement, but instead is of independent origin. Okay. That's the background. The facts that this case is based on is a buy and bust. So in December of 2016, in Manhattan, an undercover police officer bought $40 worth of heroin from a drug dealer via a middleman. The undercover officer, we call him a UC. The UC approached a middleman, asked to buy some heroin. The middleman then approached the seller, the actual drug dealer, and brought back then to the UC heroin, which the undercover walked away with after paying for. And a couple of minutes later, the undercover reports back to the team that's monitoring what's going on, positive buy, and gives a description of the seller. Gives a description as black pants, white sweater, and a black hat of the actual dealer. That's the words he used. A few minutes later, the support team goes and arrests the defendant nearby, brings the defendant to a police precinct where the undercover meets the police precinct, meets the people who arrested the defendant, and he says, yes, that's the guy. That was the actual dealer. That was about a half hour after the incident, after the arrest. The defendant was then prosecuted for the drug deal. Defense counsel moved to suppress the evidence, claiming lack of probable cause to arrest him, that there was no probable cause to arrest the defendant. And he informed the court of prosecution that if the probable cause was insufficient, he would then seek an independent source hearing to try and prevent the undercover officer from coming in and doing an in-court ID anyway. The court ordered a probable cause hearing, conducted it, and found that the arresting officer and the undercover officer did not credit the testimony. Found that the arresting officer testified about it, but found that the police lacked probable cause for the arrest. He found the arresting officer's testimony unreliable, so denied or granted the application to suppress. That evidence, physical evidence, and the ID resulting from it is suppressed unless there's an independent source. So at that point, the defendant moved for an independent source hearing to determine whether the arresting officer would be allowed to do an in-court ID at trial, or the undercover would be allowed to do an in-court ID. The judge denied it and said, I don't need a separate hearing. I'm going to consider the testimony that happened at the probable cause hearing to determine whether or not there is an independent source. And I find that there is an independent source. Case went to trial. Undercover did an in-court ID of the defendant. Defendant was convicted of criminal sale of a controlled substance in the third degree and sentenced to 6 years jail. It goes to the appellate division and they affirm it. They say that it was okay. And it goes to the Court of Appeals. And here we have a holding. And they say, first of all, the issue is preserved because the initial motion by the defendant said, I want a probable cause hearing. And if that fails, I want an independent source hearing. So it's preserved. But the issue here is now, since the probable cause failed and the in-court ID cannot be admitted unless a court found that there was an independent source, the court has to consider whether, these are the factors that the Court of Appeal says, whether there's a causal relationship between the arrest and the ID, the length and the quality of the witness's opportunity to observe the defendant before the arrest, the witness's prior familiarity with the defendant, and the nature and circumstances surrounding the supposed ID. Here, they say, the testimony at the probable cause hearing focused on whether there was probable cause for the defendant's arrest, which was based on whether the defendant matched the description given, which was black male wearing white top and jeans. There was no proof, according to the Court of Appeals, that the in-court ID was derived from the pre-arrest interaction, from the undercover's interaction. There's no description of build, height, hairstyle, complexion, physical features, face, none of that. It was just based upon the clothing match. So here the holding is that they could consider the testimony of, they never say they shouldn't have done this. They say you can consider the testimony from the probable cause hearing, but in this case, that testimony was insufficient to determine that there was an independent source, and therefore they shouldn't have allowed the in-court ID, and therefore the in-court ID was improper, and therefore the conviction is reversed, new trial ordered, with a provision, a condition, that an independent source has to come first before the trial. And that's the case of People versus Williams. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.